In 2015, over 21,000 people sought asylum in Denmark. This year, fewer than 2,300 did, and only 860 were allowed to stay. Quietly, the country once praised for its open doors now aims for zero refugees, reviewing every permission and revoking status if a single condition changes. But how did Denmark go from Europe's humanitarian haven to a nation determined to remove immigrants? And what does that policy shift truly mean for those still inside its borders? The real story starts with the numbers. Denmark's immigration numbers have not just declined, they have collapsed. In 2015, over 21,000 people applied for asylum, driven by conflict and hope for a new beginning. By 2024, that figure had shrunk to just 2,711 applications, less than 1/8 of the peak. But the real shock comes in the number of people actually allowed to stay. Only 860 asylum permits were granted in 2024, making it the second lowest total in more than 4 decades. At the height of the refugee crisis, Denmark processed thousands of new residents each year. Now, with each new policy, the doors have closed tighter. The country's official statistics show a system designed to slow, then nearly stop, the flow of new arrivals. Applications are reviewed with growing scrutiny, and the approval rate continues to fall. For every 100 people who applied in 2024, fewer than 40 were granted protection. These numbers are not just a reflection of global trends, they are the result of deliberate choices. Denmark's government has shifted from welcoming newcomers to actively limiting their chances. The numbers tell a story of reversal, with each year setting a new low. The question now is what rules and reforms have produced this sharp decline and how far the government is willing to go. In 2021, Denmark rewrote the rules for asylum and humanitarian protection with a single amendment to the Aliens Act. Instead of offering a clear path to permanent residency, the government introduced a system known as temporary protection. Under this framework, every refugee permit is issued on a strictly provisional basis. The clock starts at approval, and every 2.5 years, Danish authorities re-examine each case. Officials from the Immigration Service review current conditions in the applicant's country of origin, drawing on security assessments and expert reports. If a region is judged safe, regardless of ongoing disputes or personal circumstances, the permit can be revoked. Appeals go to the Refugee Appeals Board, but the burden now falls on the resident to prove ongoing risk. Before 2015, the process looked very different. After 5 years in Denmark, most refugees could expect their status to become permanent, with integration as the official goal. The 2021 law closed that door. Now every permit carries an expiration date, and the prospect of return is built into the system from day one. The logic is clear. Denmark's policies no longer encourage long-term settlement, but instead treat protection as a temporary exception. The result is a legal structure that enables revocation at regular intervals, shifting the focus from integration to the expectation of return. In March 2021, Denmark sent out its first batch of residency revocation notices to Syrian refugees. 94 people, some of whom had lived in Danish towns for years, were told their permits would not be renewed. The government assessment declared parts of Syria, including the Damascus region, safe enough for return. For families who had built new lives, the letter arrived like a sudden eviction. One Syrian mother, anonymized for her protection, described the moment she unfolded the notice at her kitchen table. Her children were enrolled in local schools. Her husband worked odd jobs, learning Danish in the evenings. Yet, the decision offered no exceptions for integration or family ties. The authorities cited security reports and expert testimony, concluding that general conditions no longer justified protection. Appeals were possible, but the burden shifted, and families had to prove they still faced personal risk if sent back. By the end of 2022, nearly 400 Syrians had left Denmark, some deported, others choosing to seek refuge in other European countries rather than face return to Syria. The revocation campaign began with a small group, but its message traveled quickly. For those affected, the sense of uncertainty was constant. Each review period brought fresh anxiety, and every letter carried the risk of forced departure. Even families who had begun to feel at home found themselves packing bags, unsure where they would be welcome next. Inside Denmark's departure centres, everyday life is defined by strict boundaries and constant surveillance. Residents must sign in multiple times a day, their movements tracked by digital logs and by physical head counts. Curfews are enforced each evening with doors locked and lights out at set hours. Missing a curfew or failing to report can lead to disciplinary action, including loss of remaining privileges or transfer to more restrictive facilities. Cash allowances are minimal, set well below the Danish welfare standard. Most receive only a few hundred kroner a month, enough for basic hygiene items but not much else. Cooking is banned in many buildings, and meals are provided at fixed times in communal halls. Work and education are generally off limits, permits are rarely granted, and outside employment is forbidden. Families live in small rooms, often separated from relatives who remain in other parts of the country or who have left Denmark entirely. The centres are not prisons, but few can leave for more than a few hours without permission. The system is designed to create discomfort and uncertainty. Residents exist in legal limbo, unable to move forward with their lives in Denmark, yet blocked from returning to countries deemed safe or uncooperative. For many, the only path out is voluntary departure, a choice shaped less by opportunity than by exhaustion with the daily pressures of the centre's regime. On a cold January morning, a father of two receives a letter from the Danish Immigration Service. He has lived in Aarhus for over a decade. His children were born and raised in Denmark, but a conviction for aggravated assault, resulting in a sentence just over 1 year, now triggers a new rule. The letter is blunt. His deportation is automatic, regardless of how long he has lived in Denmark or the family he would leave behind. There is no hearing about whether his children's lives will be upended, and no consideration for the Danish wife who depends on his income. The law, effective from January 2026, closes the door to appeals based on family ties for those convicted of certain violent crimes. When questioned about the policy, a spokesperson from the Ministry of Immigration and Integration stands firm. Our responsibility is to protect social cohesion and public safety. The new rules ensure that those who commit serious crimes cannot remain in Denmark, even if they have established families here. The ministry points out that previous loopholes allowed offenders to stay after serving their sentences. Now, the threshold is clear. A sentence of 1 year or more for rape or violent assault means removal, no exceptions. For families like this one, the consequences are immediate and irreversible. Lives are divided by a single court ruling and a government's claim to security. In 2018, the Danish Parliament passed a law authorizing the demolition of entire social housing blocks if more than half the residents are classified as non-Western and the area meets official thresholds for crime and poverty. Municipal notices delivered to residents in neighborhoods like Voldsmose and Mjolnerparken set in motion a process that can force families to relocate, sometimes with little warning. The law's architects argued that breaking up parallel societies would reduce segregation and crime, but for those on the receiving end, a demolition order means losing not just a home, but a community. Refugees living in these designated areas also lose eligibility for family reunification, cutting off the possibility of bringing loved ones to Denmark. Legal challenges have tested the limits of these policies in Danish and European courts. Immigration lawyers point to Article 8 of the European Convention on Human Rights, which protects the right to family and private life. The Danish Danish Refugee Council has argued that forced relocations and family separation risk violating both Article 8 and the principle of non-refoulement, especially when return is not safe or voluntary. So far, Danish courts have upheld most of the government's actions, emphasizing the state's broad authority to manage integration and urban policy. For many legal experts and advocates, the question remains whether the pursuit of social cohesion can justify such far-reaching interventions in the lives of residents who have already endured displacement and upheaval. Today, Denmark's borders define more than geography. They shape who belongs. As Europe watches, every new policy tests the limits of rights, identity, and belonging. The world will judge not just Denmark's actions, but what they reveal about the future of democracy. Where do we draw the line?